Well, hello, uncivil law fans. I hope you're having a great day as always. And we are here with a pretty major announcement from the district court in Pennsylvania, federal district court. This is the first major general decision regarding the COVID lockdowns. I would say we covered one previously on this channel from the Wisconsin State Supreme Court, but that ultimately turned on fairly esoteric issues of state law, because it was state law specific. So there wasn't a lot to be said for general rules of general applicability from that decision. But this is different. This is a federal decision, and it is written in more generalized language. So we can take principles from this and extract it, and we can apply it into other situations, which we couldn't really do with the Wisconsin case because it ultimately turned on fairly pedantic issues of how particular officials got appointed or didn't, and what specific authority those officials had under the operative state law. Fairly kind of technical. This is less technical in nature. This is more about the nature of the thing and what it is and whether it's legal or not. So this is, to the best of my knowledge, the first generalized court decision that I've seen. I've even seen some dealing with some kind of lower level church related issues or other kind of small gatherings. So I don't know that, depending on your categorization and how you like to classify these things, this may or may not count from your frame, but I think for me, this is the first major decision. And there's a certain advantage to being the first mover. And one of the advantages in the common law system is it becomes a little bit easier for everyone just to do the same thing. Of course, other courts can go different ways. They can disagree with this court, but you would anticipate that it is more likely than not that this language would be followed, all else being equal, just because it's a first mover. Because it's just easier to hit the Xerox button over and over and over again than it is to actually write something new. And in the issue of judicial efficiency and the issue of court efficiency, hitting the Xerox button is a lot easier. So all else being equal, you'd imagine the Xerox button. But of course, other courts might disagree. But we will take this decision for the value it has, try to learn. It's really good. I've done some highlighting of it because it was 66 pages long, and we'd be here forever if we read the whole thing. So in the interest of trying not to read the whole thing, I've done some pre-highlighting, trying to highlight the issues that I think are most important and will teach us the most. And it's actually a pretty good constitutional story. It actually really says a lot of stuff about basic constitutional law principles. So it's a good legal primer. It's a good constitutional primer. So it goes through a lot of constitutional issues and really highlights them and condenses them and presents them in a way that really helps to illustrate things. So with all that being said, that's enough sort of prelude. Let's get started with this decision. This is from the United States District Court. That's the trial level court. William Stickman IV writing in County of Butler, Pennsylvania, versus Thomas Wolfe, the governor of Pennsylvania. So let's read this and comment along the way as we learn. All right. The COVID-19 pandemic has impacted every aspect of American life. Since the novel coronavirus emerged in late 2019, governments throughout the world have grappled with how they can intervene in a manner that is effective to protect their citizens from getting sick and, specifically, how they can protect their healthcare systems from being overwhelmed by an onslaught of cases, hindering their ability to treat patients suffering from COVID-19 or any other emergency condition. Because if hospital beds are being filled with COVID patients, that's less hospital-based beds for other patients, which was the whole basis of flattening the curve, right? We don't want someone to die from an automobile accident just because there wasn't a bed available. So that's one of the goals. $10 from Jay Dunbar. 2 in one day. Have I died? You have not died. You know, it's just that there's so much law for us to cover. We have to do another stream. So let's do another stream. In this country, founded on a tradition of liberty enshrined in our Constitution, governments, governors, and courts have grappled with how to balance the legitimate authority of public officials in a health emergency with constitutional rights of citizens. In this case, the court is required to examine some of the measures taken by the defendant, the Pennsylvania governor, the Pennsylvania Secretary of Health, to combat the spread of the novel coronavirus. The measures at issue are the restrictions on gatherings and the order of closing non-life sustaining businesses and directing Pennsylvanians to stay at home. After which, that's kind of similar to other states, right? This is language that is very broadly reminiscent of other things, which is why it's more generally applicable. So we're not focusing on the specific language of the specific order, right? We're a little bit more generalized, so we can abstract it more than we could in the Wisconsin case, where it was really kind of technical and we couldn't abstract it. This is more abstractable, so that's more helpful for us understanding the law. After reviewing the record in this case, including numerous exhibits and witness testimony, the courts believe the defendants undertook their actions in a well-intentioned effort to protect Pennsylvanians from the virus. However, good intentions towards a laudable end are not enough to uphold governmental actions against constitutional challenge. Thank you, Lemon Party, for being a new supporter. Appreciate it. And the greatest threats to our system of constitutional liberties may arise when the ends are laudable and the intent is good, especially in time of emergency, right? Bad facts make bad law. So if there's an ongoing crisis, that might be a problem and a reason for us to pay more attention. In an emergency, even a vigilant public may let down its guard over its constitutional liberties, only to find that liberties, once relinquished, are hard to recoup. Rights given away maybe not be so easily recaptured. And which, while expedient in the face of the emergency situation, may persist long after the emergency danger has passed. Yeah. Right here, I'll quote Jordan B. Peterson to say, do what is meaningful, not as what is expedient, I guess is one of the lessons from this court decision. Thus, in reviewing the emergency measures, the job of the court is made more difficult by the delicate balancing that the court must undertake. The court is guided in this balancing by principles of established constitutional jurisprudence. Always a good place to start. And then we got a couple pages of background that inform us how the coronavirus came to be and the various regulations that went on and all the steps they took. History, blah, blah, blah. All right, let's get to the analysis. The defendants, which is the government, argue that the county plaintiffs are not proper plaintiffs. They contend that the county plaintiffs lack standing to bring an action under 42 U.S.C. 1983. The court holds that the county plaintiffs are not proper parties. So this was titled County of Butler versus Wolf. And so County of Butler is no longer a proper plaintiff. So if this gets appealed, it will have its name changed because County of Butler is not a party to this anymore. So why is that? Well, it's pretty simple, actually. Section 1983 does not confer any substantive rights, but really provides a cause of action for deprivation of color rights. So 1983 doesn't give you rights unto itself. It's a procedural mechanism. It's a mechanism that says here is a basis for which you can sue, but it doesn't unto itself give you a basis to sue. You have to find another reason to sue. It's just the procedural mechanism. So it doesn't give you substantive rights. It gives you a procedural mechanism. Okay, and then that's important because counties are creatures of the state. Yeah, they don't possess rights under the Constitution. Right. They cannot assert a claim against the state of which they are a creation for violating rights they do not possess. A municipal corporation created by the state for the better ordering of government has no privileges or immunities under the federal Constitution which may invoke in opposition to the will of its creator. Yeah, so at this point, to the chagrin of the chat, I am sure, I'd like to quote the words of the wise prophet, Britney Spears, who said, "I'm a slave for you. I can't hold it. I can't control it. I'm a slave for you. I won't deny it. I'm not trying to hide it." These are the appropriate words to describe the situation with counties and cities. Cities and counties are but creatures of the state. They exist at the pleasure of the state and at its will, and they can be created and abolished without any due process at any time because the state feels like it. Any remedy they might have under their state constitution, that's an issue for the state constitution, not federal law. So if there's a state constitutional provision that comes into play that says, hey, you can't do this because the state constitution says you can't, well, 1983 is the wrong cause of action. Go talk about it somewhere else. That's not the right cause here. Because if your cause is we have rights, it's like, no, you don't. You are but a creature of our manifest will. You will bow to our mercies. And it's like, yep, that's pretty much correct, right? Cities and states Cities and counties don't exist unless the state says they do. So you can't sue your master. Right. Okay, so that was pretty easy. All right, so let's move on to the individual plaintiffs. All right, so now moving on to the individual plaintiffs, because we got some individuals along here too. Before the moving into the substance of the plaintiff's constitutional claims, the court will examine what lens it should review those claims under. So this is a good constitutional law primer. In other words, what is the appropriate standard or regime of standards the court must use to weigh the constitutionality of the claim? How do we measure this? What is the way we measure constitutional claims? Good question. Plaintiffs base their constitutional arguments on ordinary constitutional measures, whereas defendants argue the action should be afforded a more deferential standard as an emergency measure. So, question number one, are we under ordinary review or are we under some sort of extraordinary emergency review? All right, good question. Over the last century, the federal courts have developed a regime of tiered scrutiny for examining most constitutional cases: rational basis, intermediate scrutiny, and strict scrutiny. This language should be fairly familiar to anyone who's watched this channel. You have heard me use words like rational basis, intermediate scrutiny, and strict scrutiny, hopefully quite a lot. This is the normal tiers we use in normal constitutional analysis land. The appropriate standard of review depends on the nature of the claim and specifically the nature of the right that is allegedly infringed. In this case, the defendant points, that would be the government, that would be more specifically the governor. The governor points to the emergency nature of the challenged measures and correctly argues they have broad authority under state police powers in reacting to emergency situations relating to police and health. Yes, just as a brief reminder here, when we use the word police powers in this sense, we don't mean police in the sense of, law enforcement police. When we talk about police powers, we mean all the power of government, general power of government. So the federal government doesn't have police powers because they don't have general power. They're limited powers. States have police powers. They have general power, including over public health and safety. So that's what we're talking about. The general power to do general stuff. That would be the kind of thing that states do. And so the government says, we have the general power to do stuff. And the court is like, yes, you're generally correct, because that makes sense. The governor contends that the traditional standards of constitutional scrutiny should not apply. So the three-part test we just discussed with rational basis, intermediate scrutiny, strict scrutiny, we shouldn't do that. But rather, we should follow a more deferential standard, as articulated in Jacobson versus Massachusetts 1905, a case we've also covered on this channel. So we should use Jacobson instead of that traditional three-part test. The defendants contend Jacobson sets forth a standard that grants almost extraordinary deference to actions responding to health crises, and based on that deference, plaintiffs' claims are doomed to fail. In other words, defendants argue no matter what level of traditional scrutiny that would require, a more deferential standard is appropriate. So the government says all that rational basis, intermediate scrutiny, strict scrutiny stuff is not even the right framework to use in this situation. We're in an entirely different category. We're in a Jacobson world, and in Jacobson world, the government can get away with quite a lot more. So are we in traditional normal world where we're doing the three-part thing, or are we in Jacobson world where we're saying, oh, we're about one or two steps short of the king can do no wrong? So which of those two universes are we in? That makes a big difference. And that would be, incidentally, like one of the first places a court could theoretically go the other way on this, right? But let's listen to the rationale of why they think the traditional test applies, not the Jacobson test. So to remind you about what Jacobson 1905 said, Jacobson, the Supreme Court of the United States upheld a Massachusetts statute that allowed the cities to require all residents to be vaccinated for smallpox. Mandatory vaccines. That was Jacobson. Jacobson was prosecuted for refusing to comply. The Supreme Court in 1905 rejected out of hand the argument that the measure violated the Constitution's preamble or spirit, explaining that only specific substantial provisions of the Constitution give rise to claims, which is perfectly fair and remains true today. The preamble is not substantive. It is philosophical. You can't sue on the preamble of the Constitution today either. The Supreme Court in 1905 continued by explaining that the police power, which again, remind you, is the general power of government to do general stuff, the police power of state must be held to embrace at least such reasonable regulations established directly by legislative enactments as will protect public health and safety, including, in the specific example, mandatory vaccines. So if they ever come out with a COVID vaccine and they want to mandatorily vaccinate people, Jacobson would probably be the case on point. Although Jacobson court unquestionably afforded a substantial level of deference and discretion to the state, it did not hold the deference as limitless. So even Jacobson has its limits, which is nice. Rather, it closed its opinion with a caveat to the contrary. So the Supreme Court giveth and it taketh away. They wrote some language and said, rather, before closing this opinion, we deem it appropriate, in order to prevent misapprehension of our views, to observe, perhaps to repeat, a thought already sufficiently expressed, namely, the police power of the state, whether expressed directly by the legislature or by a local body acting under its authority, may be exercised in such circumstances or by regulations so arbitrary and oppressive in particular cases as to justify the interference of courts to prevent wrong and oppression. So the Supreme Court did say there was a line somewhere, even in 1905, which is kind of nice. So there's no question then, even under this plain language, a public health measure can violate the Constitution. All right. But then the court gets into the more notable aspect of this, which is Jacobson was decided over a century ago. And since that time, there's been a substantial development of federal constitutional area in the law of civil liberties, or perhaps to put it a slightly different way, in the area of just constitutional law analysis. As a general matter, this development has seen a jurisprudence shift, whereby federal courts have given greater deference to considerations of individual liberties. Yeah, the Supreme Court didn't really take individual liberties really seriously until the 1930s, arguably, and arguably, depending on your frame, after that. But I always said, like, 1930s was about the time that the Supreme Court said, hey, there's a Bill of Rights, maybe we should do something about it. So yeah, you know, there was some change since Jacobson. Yeah, in 1905, they hadn't discovered the Bill of Rights yet. In 1930s, they dusted off it as like, oh, maybe there's a thing here we should pay attention to. Yeah. So as a general matter, this development has seen this split, or this development. The century of development has seen the creation of the tiered levels of scrutiny that we discussed before. Rational basis, intermediate scrutiny, strict scrutiny. This language did not exist when Jacobson was decided. So there's your first big takeaway. Like, why didn't Jacobson use the three-tier approach? Because it hadn't been invented yet. Also because the Supreme Court hadn't discovered the Bill of Rights yet. They lost those pages of the Constitution. So they hadn't invented the three tiers of scrutiny. That's why Jacobson never discussed it. So Jacobson is kind of sitting off here in constitutional no man's land because it doesn't really work anymore, but as we've learned from our other cases, it remains good law, right? So it's up to the Supreme Court to overturn it. So even though its underpinnings have been completely undermined, it is still good law. We recently discussed that in the National Coalition of Men with the draft, right? And the Fifth Circuit case, we discussed that. So just because it has been undermined doesn't mean it's not good law. It is good law. So again, if you're trying to force vaccinations on people, Jacobson is still your go-to. But it's notable that Jacobson didn't use the three-tier analysis because it didn't exist yet. While Jacobson has been cited by some modern courts as ongoing support for broad, hands-off deference to state authorities in matters of health, other courts and commentators have questioned whether it remains instructive in light of intervening judicial developments. The word instructive here is probably doing a lot of weightlifting. It is binding, it is controlling, but the degree to which it's instructive suggests the degree to which it would be informative as to other things beyond its mandate. So if it were instructive, it would be giving us instructions, which is to say how to interpret other cases. If it's not instructive, then it is only as valid as it is, and it's basically dead letter beyond that. So does it give us instructions, or should we kind of ignore it? All right, that's a good question. The court shares concerns expressed by Justice Alito, as well as some professors in a paper, and believes an extraordinary deferential standard based on Jacobson is not appropriate in this case. And you could see a court going the other way, but that would be one way or a split. Could Jacobson be reaffirmed and modified to say it's contingent on strict scrutiny analysis? By the Supreme Court, yes, it absolutely could. And that would be the operative thing, So if it ever comes to pass, it would absolutely, one would presume it would have to be modified by the Supreme Court, one way or another. So yes, you would expect that. But if it ever comes to pass, the lower courts will have no choice but to say, yep, Jacobson, so therefore they can do what they want. It's up to the Supreme Court to modify it. So, but that would happen. All right, so anyways, this court thinks that the exceptional standard is not appropriate here. So therefore, we'll apply the regular test, the regular 3-part test. That's good. We all know that one. So let's just stick with that. 2 considerations inform this decision: the ongoing and open-ended nature of the restrictions and the need for independent judiciary to serve as a check for the exercise of emergency power. So here's some reasons why we're not going to extend. We're not going to extend because this is ongoing and open-ended. It has no end in sight, and there's a reason for the government the judiciary to check the power. So that's a good reason. First, John says, okay, so it's unconstitutional. What remedy do the people have? We haven't gotten that far, John. We haven't gotten that far into the opinion. So far, we have only gotten to we shouldn't apply Jacobson. We should apply the 3-part test. We have not gone far enough into the opinion of this is unconstitutional. We have only so far determined Jacobson is not a thing. So don't skip ahead on the page. Anyways. First, the ongoing indefinite measure. The extraordinary measures taken by defendants in this case were promulgated, which is to say, put into force, beginning in March 6 months ago. What was initially billed as a temporary measure to flatten the curve and protect hospital capacity has become open-ended and ongoing restrictions aimed at a very different end, stopping the spread of an infectious disease and preventing new cases from arising, which requires ongoing and open-ended efforts. They changed the deal on us midway. Pray I don't change it any further, says Darth Vader. Further, while the harshest measures have been suspended, the government, or governor, more specifically, the governor admits they remain in place and they can be reinstated sua sponte, and if and when they see fit. So the measures are not active, but they could be if we say so. All right. Sam Robinson, a deputy chief of staff of the governor, testified as much when he asked if there was a phase of reopening beyond the green phase when there'd be no restrictions. So Pennsylvania adopted a color-coded system, red, yellow, green, and there's a green phase, and presumably there'd be a phase beyond green, which is like no restrictions. So he's asked, is there a phase beyond green when we just are unregulated? Question, you can't move from green to no restrictions, whatever. There's no way to do that under the system, right? Answer. So there's a number of options for, when a post-green potentiality could look like. And it could just be to entirely remove all the restrictions or replacement with other restrictions, maybe not a color-coordinated system. There are certainly other options on the July 15th order we've referenced from last week, certainly an approach that was changed from not strictly speaking within the red, yellow, green framework that was originally contemplated. And we're doing our best to respond to the pandemic nimbly and not being locked into a specific approach, but to target areas where we see it spread and things that we can do to balance the need to reopen the economy and continuing moving Pennsylvania back towards a new normal that governors and others have talked about for some time, while taking targeted migration steps to prevent the spread of the virus, which is what was embodied in the July 15th order. Question. What is the new normal? What does the governor mean by the new normal? What does that mean? Good question. Answer, yes, we're still evolving into it. We have no idea. But obviously, it's more consciousness about the steps to prevent the spread of COVID and the ways Pennsylvanians are having to be more conscious of those migration efforts and to take steps to be responsible to protect fellow Pennsylvanians. Translation, I have literally no idea whatsoever what new normal means. I have none of the clues. That's what that means. All right. Yeah. Courts are willing to give temporary deference to temporary measures aimed at remediating a fleeting crisis. Examples include a natural disaster, civil unrest, or other man-made emergencies. There is no question, as Justice Alito reasoned in a case called Calvary Chapel, that courts may provide state and local officials greater deference when making time-sensitive decisions in the maelstrom of an emergency. In the event of an emergency, the executive must be free to do some stuff. But the deference can't go on forever. It is no longer March. It is now September. These are two different things. And the record makes clear defendants have no anticipated end date to their emergency interventions. Court must surely be willing to give in a fleeting crisis, But here the duration of the crisis, which has turned into weeks into months, already exceeds disasters or other episodic emergencies, and its length remains uncertain. Faced with ongoing interventions of indeterminate length, suspension of normal conventional levels of scrutiny may ultimately lead to the suspension of liberties themselves. Normally when we do this, it's for very temporary times and very temporary emergencies. There is an ongoing riot. There is an ongoing hurricane. We need people to evacuate an area. We need people to board up their homes. We need people to, we need to put in sort of drastic measures, because of this ongoing emergency. But hurricanes and riots, unless you're in Portland, where you don't know how to stop riots because you can't be bothered. So unless you're in Portland, you can't be bothered to stop the riot. Normally, they don't last forever. And the only reason they haven't stopped in Portland is because Portland hasn't been bothered to try. Anytime Portland would like to be bothered to try, that'd be great. And then they could exert emergency measures to stop the rioting, or stop the hurricane, or stop the tornado, or whatever. But it's been a little bit now, so let's take note of that. While respecting the immediate role of the political branches to address an emergent situation, the judiciary can't be overly deferential to the decisions. Deference doesn't last forever, yeah. To do so risks subordinating the guarantees of the Constitution, guarantees which are the patrimony of every citizen. There's that patriarchy that the left loves to talk about so much. You want to know where the patriarchy is? You want to know where the patriarchy is? It's the thing that gives you rights under the Constitution. That's the patriarchy. Patriarchy confirmed. The patriarchy is the thing that gives you rights because it's patrimony. Patriarchy confirmed. It's the thing that gives you rights. This is especially the case whereas here, measures directly impacting citizens are taken outside normal legislative or administrative procedures by the governor alone. So it wasn't even like the legislature doing stuff, and that's also a problem. There's no question our founders abhor the concept of a one-person rule. That's a problem. They decried government by fiat, also a problem. Absent a robust system of checks and balances, the guarantees of liberty set forth in the Constitution are just ink on parchment. Ouch. 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 There's no question that a global pandemic poses serious challenges for the government and to all Americans, but the response to this pandemic, or for that matter any emergency, cannot be permitted to undermine our system of constitutional liberties or systems of checks and balances protecting those liberties. This is pretty good language, man. I love this stuff. Using normal levels of scrutiny in emergency situations does not prevent governments from taking extraordinary actions to face emergency situations, which is kind of like what I was saying. Like, in the face of the pandemic, in the face of the fog of war, in the face of the uncertainty, and I said this back in March, and a couple people were critical of me for it, but I still stand by it. Like, when people asked me initially, like in March, is this constitutional? I'm like, yeah, probably. It passed strict scrutiny, and I'm still kind of like of that opinion. In March, like in the fog of war, in the fog of the uncertainty, it's like we will stretch it. We'll stretch it, but we can't stretch it forever. The stretching has come to an end. So yeah, I think what I said in March is correct, and I think now this is correct because we have more facts, we have more understanding, we know what's going on, and we know it's going to last forever. When it was, anyone remember when it was 2 weeks to stop? 2 weeks to flatten the curve. Wasn't that the motto? 2 weeks to flatten the curve. Anyone remember that? When it was 2 weeks to flatten the curve, I'm like, yeah, that probably passes strict scrutiny. Now it's more like 8 months or 5 months or however many months it is between February and March and now. How many months between March and now? I don't even know. Some number of months. Okay, let's press on. As the Supreme Court has observed, the Constitution was adopted in a period of emergency. That too. It grants a power to the federal government, and its limitation of power was determined in the light of the emergency, and they are not altered by emergencies. Deep. Amazing. Wow. The Constitution itself if we're talking about like what's necessary for emergencies, well, not to put too fine a point on it, but the Constitution itself was, kind of adopted under an emergency. So, there's that. Yep. All right. All right. So now that we've gotten into sort of the philosophical stuff, let's discuss more of the substance of the particular stuff. What are we talking about? There was an order in July that imposed a limitation on events and gatherings of 25 people for indoor gatherings and 250 people for outdoor gatherings, and then defines gatherings to be gatherings. You know what a gathering is. The order has no end date or other mechanism for expiration, but rather purports to remain in effect until further notice. Yeah. The gathering limits specific exemptions for religious gatherings and certain commercial operations as set forth in the order. The section of the order imposes an occupancy limit of 25% of state fire code maximum occupancy for bars and apparently restaurants. The May order permits businesses, other than businesses in retail, food, personal services such as barbers and salons and gyms, all of which are under different guidance, to operate at either 50% or 75% of their limits. Okay, great. The record is unclear as to whether the order's limiting size of gatherings apply to protests. Nice. The plain language of the order makes no exception for protests, which seemingly run directly contrary to the plain language of the order that states any gathering for a planned or spontaneous event of greater than 250 individuals, which by its own terms would include a protest. However, the record unequivocally shows the governor have permitted the protests. And the governor even participated in a protest, which exceeded the limitations set forth in his order, and he did not comply with other restrictions mandating social distancing and wearing a mask. So even though the order by its own terms would seem to apply to a protest, because it's a gathering of 250 individuals, the governor himself, even though it's the governor's order, participated in a protest, even though it defies his own order. Nice. That's good. $4.99 from Ghost of Recon. I will subsidize a beer for the host. Thank you. I appreciate that. The plaintiffs argue the limits on the gatherings imposed by a defendant violate the right of assembly and the right of freedom of speech. Somewhat. It seems like that. Specifically, some political plaintiffs, such as these people named, contend that the gatherings limit unconstitutionally and violate their right to hold campaign gatherings, fundraisers, and other events. Defendants contend that gathering limits pass constitutional muster because, okay, so here's the reason that they're legal. Here's the reasons that they're illegal. They're illegal because they are exercises of the defendant's police power in an emergency and are content neutral. $10 from Adam W., who says the legislature statutorily receded the governor's emergency power already 3 months ago, a power in purview and granted. The Pennsylvania Supreme Court went against the rule of law on this matter, though. That sucks. That sucks. But that does seem like an issue of state law. That's not an issue of federal law. What the effect of that does seem squarely within the confines of the Pennsylvania Supreme Court. So I don't really know what to say except yell at the Pennsylvania Supreme Court because that seems like some BS based on your description. But yeah, that's a state law issue. So I guess it doesn't violate the rule of law because the Pennsylvania Supreme Court said so for some reason. Okay. Well, that's the end of that case. All right. As to this case, they contend that even in traditional public forum, the government may impose a content-neutral time, place, and manner restriction. You've heard this language before from me too. Provided the restrictions are justified without reference to the content of the speech, which was what makes it content-neutral, and they're narrowly tailored to serve a governmental interest, and they leave open ample opportunities for communication of information. So, first idea is this is intermediate scrutiny because it's content-neutral, which, depending on how you view what they did with the protests, may make it not content neutral. It's content neutral on its face, but not content neutral as applied. So that's a factor. So maybe we should be doing strict scrutiny. So that's a thing. Anyways, the court must first determine which standard applies. Is this rational basis? Is this intermediate scrutiny, or is this strict scrutiny? The right of assembly is a fundamental right enshrined in the First Amendment. It is mentioned. Although the right to assembly is not commingled with the freedom of speech, they've been identified as the same. So they're not the same thing, but they basically get the same treatment, which makes sense. In this case, some of the plaintiffs seek to assemble relative to their campaigns for public office, which incidentally makes it political speech, which is normally considered of the highest value in the speech hierarchy. Political speech usually goes to the top of the list. This type of gathering is unquestionably expressive in nature and therefore fits neatly into the practice of looking at right of assembly challenges through the lens of free speech, which, no problem, that makes sense. The question before this court is whether strict scrutiny or intermediate scrutiny should apply. Following free speech jurisprudence, the plaintiff's challenge are what is akin to a time, place, manner restriction. The court must determine whether restrictions are content-based or content-neutral. To do so, the court must determine whether the limits on expressive gatherings while permitting others. To make that determination, they must disentangle the language of the orders from their testimony. So they must look at what the orders do rather than what they said under oath, which seems fair. And then they say, having reviewed the record, the court does not believe the orders do in fact make allowance for protests. And I will chide the court here slightly because, yes, the orders on their face don't do it. But as the orders have been applied, they have. So I think the court can and should look past the language of the order and also look to see what has been done in the real world. For reasons that, the court doesn't want to do that. So the court isn't going to look at what's done in the real world and just look at the order and says, well, the order is neutral on its face, which it is on its face. If it were up to me, I'd probably be looking at what actually happened because maybe the order isn't what's written on the page. What is done beats what is said, right? But they say, okay, it's content neutral, fine. As such, the orders apply to all expressive gatherings, and therefore they're content neutral. Sure, fine, let's go with that. They're content neutral, so intermediate scrutiny, great. All right, I'm not sure I agree, but all right, fine. As in a prior case, the plaintiff makes much of the fact that certain gatherings are limited by a specific quota, while people are free to congregate in stores and similar businesses based on a percentage of the occupancy limit. The Supreme Court has explained the principle of inquiry in determining content neutrality in cases regarding time, place, and manner is whether the government has adopted a regulation of speech because of disagreement with the message it conveys. That would make sense. A regulation that serves a purpose unrelated to the content of expression is deemed neutral, even if it has an incidental effect on some speakers or message, but not others. Based on that definition, they're content neutral. Limiting people to, while not permitting commercial gatherings, has nothing to do with the message, which, fine. Under First Amendment jurisprudence, a non-content-based restriction is not subject to strict scrutiny. It's a very fancy way of saying intermediate scrutiny, but still must be tailored to narrowly tailor this interest, which is the test for intermediate scrutiny. If it were strict scrutiny, we'd be talking about least restrictive means. We're not talking about strict scrutiny, we're talking about intermediate scrutiny, so not least restrictive, just narrowly tailored. So it has to be narrowly tailored, not the most narrowly tailored. Yeah. The Supreme Court has explained the requirement of narrow tailoring is satisfied so long as the regulation promotes a substantial governmental interest that would be achieved less effectively absent the regulation. The standard does not mean that time, place, or manner regulations may burn substantially more speech than is necessary to further the legitimate interests, because it has to be narrowly tailored. Government may not regulate expression in such a manner that substantial portion of speech does not serve to advance its goals. So, if you are burning a lot more speech than you have to, that would make it not narrowly tailored. It doesn't have to be perfect. It doesn't have to be perfect, but if there's a lot of it that is not necessary, then you're not narrowly tailored. So strict scrutiny is much more careful, much more akin to being perfect. Intermediate scrutiny doesn't have to be perfect. It just has to be narrowly tailored. If it has a substantial amount that's not, it's not narrowly tailored. Now, is it? Try harder. Okay, so these limits are not narrowly tailored, says the court. So you didn't do that. Rather, they place a substantial burden on gatherings, more than is needed to achieve their purpose. You went beyond what was necessary. This is not mere supposition, but rather is highlighted by the government's own actions. While permitting commercial gatherings at a percentage of occupancy may not render the restrictions on other gatherings content-based, they do highlight the lack of narrow tailoring. So it's like, why are you putting some as a hard cap of number, and why are you doing it in some places in line of on percentage of occupancy. There's nothing really that's really going there. So, we need to try a little bit harder. Moreover, the record in this case failed to establish any evidence that the specific number limits. So this is where they said a hard cap, not 25%, but 25 people. So when they said 25 people, there was no evidence as to why that was necessary. Why did you pick 25? Well, I don't know. And much less, so there was no evidence, much less that they target and eliminate no more than the exact source of the evil. You're just making stuff up now. You can't do that, really. You got to try a little bit harder. Mr. Robinson testified that the limits were designed to prevent mega spreading events. However, when asked for an example, the large protests, often featuring numbers far in excess of the limits, led to any known mega spreading event, he was unable to point to a specific mega spreading incident. I love this very much. I love this very much because the way the question was phrased is so great from the court. So the court could have asked, "Are you aware of any event of more than the cap?" And I'm sure he could have come up with one. But the court was slightly more clever. They asked the narrower question: all these mass protests that have been beyond the number, have they led to any mega spreading incident? And of course, him being a good politician said, "No, I'm not aware of any." So I love this because, it shouldn't really matter why people are gathered. I don't think COVID knows about Black Lives Matter. In fact, I don't think COVID thinks Black Lives Matter. As best as I can tell, it doesn't. And so, he's saying, well, have these mass protests led to any instance of infection? Nope. Not aware of any of that. Oh, okay. Well, then it must be completely baseless. Ta-da! I love that very much. It's such a great exposing question. Good for the court. Further, the limitations are not narrowly tailored in that they do not address the specific experience of the virus across the Commonwealth of Pennsylvania. Because all Pennsylvania counties are currently in the green phase, the same restrictions apply everywhere in our state. Pennsylvania has nearly 14 million residents across 67 counties. Pennsylvania has dense urban areas, commuter communities servicing New York, small towns, and vast expanses of rural communities. The virus's prevalence varies over a greater diversity of the Commonwealth, as do resources vary to combat population. Despite the diversity, there's a one-size-fits-all approach. So despite the fact that we have some places that are like middle of nowhere farms where you can't find another human being for like 100 miles, and the city of Philadelphia, which is a metropolitan area, worthy of mention, along the same breath at least as New York. Of course, New York has a lot more people, but it's mentionable in the same breath of New York. So despite these disparities, you have the same policies everywhere. How is that tailored? Doesn't feel very tailored. Okay. In an analogous situation examining restrictions on religious practice, while permitting retail operations, the court aptly observed, if social distancing is good enough for Home Depot and Kroger, which is a grocery store for those of you who don't know, it's good enough for in-person religious services, which, unlike the foregoing, benefit from constitutional protection. So it's like, if you have one policy for Home Depot, should be good enough for your church. Of the two, churches get more protection than Home Depot. Churches should get more protection, and yet you put them in a lesser category for no reason. That doesn't make sense. And thus, the limits are unconstitutional because they don't make any sense. Okay, that makes sense. All right. Plaintiffs assert the components of the orders closing non-life-sustaining businesses and imposing a lockdown violate their liberty guaranteed by due process. So Pennsylvania, like many places, has tried to classify between essential and non-essential, and then said, some of these are non-essential, and closed all the non-essential ones. Okay, let's give that a shot. Substantive due process not an independent right. Much like 1983, substantive due process is not a right. It's process. It's procedure. It's not substance. It's in the name. It's in the name. Although it's called substantive due process, which makes it really confusing. And also, incidentally, why I don't think it exists. I don't think such a thing as substantive due process exists. The reason that this is such an aside, but what the hell, it's my channel. The reason that they created substantive due process was to solve a problem that the court itself created. The problem the court itself created was they nuked the Privileges and Immunities Clause from this first section of the 14th Amendment. It was perfectly good. It was perfectly serviceable. It was doing what it needed to do. And then the Supreme Court nuked it. They nuked it hard. They nuked it hard. And then, rather than try to fix their mistake by unnuking it, they came up with this idea of like, what if due process, which by its very name is process and procedure, what if it wasn't just process and procedure? What if it was substantive? And if you're thinking to yourself, what? That doesn't make any sense. How can process be substantive? Ding, ding, ding. You're with me. It doesn't make any sense. You can't have substantive process. These two words don't go to each other. One or the other, man. Pick a side. We're at war. So, at this point in history, I'm not sure what difference it would really make, because if we fixed it, we'd probably just be exactly where we would be that we are now. So it probably wouldn't make that much difference, except it would be a lot more intellectually pure. So anyways, substantive due process, which is a thing we invented to get around the fact that we nuked the Privileges and Immunities Clause because, I don't know, reasons, is not a substantive right unto itself, but rather recognition the government may not infringe upon certain freedoms enjoyed by people as a component of the ordered system of liberty. Yeah, that's, yeah. All right, so anyways, the governor issued the first stay-at-home order on March the 23rd, mandating some stuff. Basically, stay at home. Although the initial stay-at-home order had an expiration date of 2 weeks, 2 weeks to flatten the curve, it was amended by subsequent orders to extend it to later dates. Ultimately, upon moving of several counties, and later all counties, into the green phase, the stay-at-home orders were suspended. Not repealed, mind you, suspended. The suspension is not rescission, and because they may reimpose it at any time on their will. It's just something they can do at any time that they want. So, whatever. The plaintiffs argue the lockdowns effectuated by the stay-home orders violate the substantive due process rights secured by the 14th Amendment. Okay. They contend the orders do not impose traditional disease control measures, such as quarantine or isolation, but rather involuntarily and without due process confine the entirety of the population of the Commonwealth to their homes, absent a specific approved purpose. So this isn't quarantine or isolation for specific designated people. This is the entirety of the Commonwealth. Those are different things. The plaintiffs contend the lockdown violated their fundamental right to intrastate travel and freedom of movement. We have the right to move around and stuff. That's the thing we have the right to do. The plaintiffs argue that while the power to involuntarily confine individuals is generally strictly limited by law, the lockdown was overbroad and far exceeded legitimate governmental need and authority. So, there is some need to involuntarily confine individuals for a quarantine, among other reasons, but the entirety of the state, I don't know, man. The defendants argue the question of whether these stay-at-home provisions are unconstitutional is moot. So the governor said, okay, that thing that we did, it doesn't matter anymore because it doesn't apply. We all cool now? That's mootness. We good? It doesn't apply anymore, so that means it doesn't apply. We good? We good? That was the governor's question. According to the governor, the stay-at-home orders have been suspended. As such, the citizens of Pennsylvania are free to leave their homes for any purpose. What does the district court have to say about that? Well, the doctrine of mootness, which is where, a case doesn't exist anymore, is rooted in Article 3, which governs federal cases over cases and controversies. If there's no controversy anymore, the case is moot. At this point, I'd like to remind you that Flynn is still being prosecuted, even though there's no case or controversy, because, I don't know, the D.C. Court of Appeals en banc says so. But don't worry about it. We're not talking about Judge Flynn right now. We're talking about normal constitutional law where, normally we care about these things. Federal courts can only entertain actions if they present a live dispute. Yeah. However, the voluntary cessation doctrine may serve as an exception to mootness, which we covered in the New York State Pistol and Rifle Association case. We talked about voluntary cessation. It is well so that a defendant's voluntary cessation of challenge practice does not deprive the federal court of its power to determine the legality of the practice. As the Third Circuit has explained, one scenario in which we're reluctant to declare a case moot is where the defendant argues mootness because of some action it took unilaterally after litigation began. This situation is often called voluntary cessation, and will moot a case only if it's absolutely clear the alleged wrongful behavior could not be reasonably expected to recur. So if you're going to stop, you actually have to stop. You actually have to stop. You can't pause and then come back and then pause and come back. No, you can't do that. When a plaintiff seeks declaratory relief, which is when you ask the court to declare stuff, normally you're asking them, what are my rights? Please declare them. Please tell me what they are so that we're all clear. That's declaratory relief. So defendant arguing mootness must show there's no reasonable likelihood that this judgment would affect future conduct. So, yeah. Here, the application of this voluntary cessation doctrine precludes a determination that loosening of the restrictions is, in subsequent orders, moots the case. It makes it irrelevant. The language of all the order merely amends the operation of the orders. It does not abrogate them, which is to remove them. They remain in place, and they're only suspended, which is not the same thing as removing them. Mr. Robinson specifically testified, as we sit here today, is there a stay-at-home order in place? There is. There is a stay-at-home order in place, but it's been modified by subsequent orders that have been put out. Well, it's still there then. Although the order is in suspension, it remains incorporated into the most recent mitigation orders, and it can be reinstated any time that Caesar dictates. All hail Caesar. There is no reason that under this voluntary cessation doctrine the court can examine the issue, which remains fully ripe. So there's no reason that we can't examine this thing because the orders remain in place and it could come back at any time, and yeah, so we don't have to give it up because, yeah. All right, so now we have to get into the precedent, which is like when we're thinking about what this order is, the stay-at-home order. What is the precedent, both in law and in fact? What have we done in prior incidences in this country? How have we dealt with prior situations in this country? What can we learn from prior outbreaks and how we've dealt with them? Is this what we've done in the past, or is it different than what we've done in the past? Let's discuss what we did in the past to figure out, is this the same as what we did in the past or different? All right, so let's figure that out. To determine whether the stay-at-home orders are constitutional, we must determine what level of scrutiny applies. Rational basis, intermediate scrutiny, strict scrutiny. Yeah. To do so, the court has to determine what a population lockdown, which is to say everybody, the effect of the stay-home orders is from a legal perspective. What is this thing? This is not necessarily an easy task. Although the nation has faced a variety of epidemics and pandemics, and state and local governments have employed a variety of interventions, there have never previously been lockdowns of entire populations must last for lengthy and indefinite period of times. So the Supreme Court, I wish. The District Court is pointing out that this is unprecedented. Although we have dealt with epidemics and pandemics in the past, we have never, ever before just tried to lock down the entirety of a population, much less for ongoing, indefinite, and endless periods of time. This is not a thing we've ever done before. This is a novelty. That might be a fact that's worthy of notice. Haha! This is completely unprecedented in our history. Maybe that's a factor we should take note of. Let's read some more. One term that has been frequently employed to describe the lockdowns is quarantine. Quarantines have been used throughout history to slow the spread of infectious disease by isolating the infected and to others exposed by disease. So yeah, one of the languages they've tried is, this is a quarantine. So is it a quarantine? Let's find out. The plain language of the relevant statute, which defines what quarantines are, makes it clear that this lockdown is not a quarantine. So quarantines are actually defined in law. They're defined, and this is not that. So why is it not a quarantine? I'm so glad you asked. A quarantine requires as a threshold matter that a person subject to limitation of freedom of movement be exposed to the disease. You have to be infected. Moreover, critically, the duration of the quarantine is statutorily limited to the period of time equal to the longest usual incubation period of the disease. So it can't be longer than the incubation period. This lockdown plainly exceeded that period. Indeed, the defendant's witness conceded upon examination the lockdown cannot be considered a quarantine, because no, not so much. Defendant's attempts, that would be again the governor of Pennsylvania, this would be Governor Wolf, your governor in Pennsylvania, Governor Wolf, said the following. He attempted to justify this extraordinary mitigation effect by pointing to actions taken to combat the Spanish flu. That's a good example. So is this similar to what we did in the Spanish flu? Let's find out. Ms. Boating testified that in response to the Spanish flu, much of the same mitigation steps were taken. The closing of bars, saloons, cancellation of vaudeville shows, as they then called them, and cabarets, the promotion of large events. So some of the same actions we're taking now have been taken in the past. But an examination of the history of mitigation effects in response to the Spanish flu, by far the deadliest pandemic in history, reveals that nothing remotely approaching the lockdowns was imposed. So, this, even though this is much less deadly than the Spanish flu, by far less deadly than the Spanish flu, you have taken measures they didn't even dream of in the Spanish flu. Yes, they closed movie theaters, and they closed bars, and they closed some other things. But you've taken steps well beyond what they did in the Spanish flu. You've come up with whole new ways to oppress people. How exciting. The records show the Pennsylvania Health Commissioner, Franklin Royer, the 1918 Public Health Commissioner. Missed the date on that one, kind of an important detail. The 1918 Public Health Commissioner, Franklin Royer. Imposed an order which closed all public places of entertainment, including theaters, moving picture establishments, movie theaters, saloons, and dance halls, and prohibited all meetings of every description until further notice. The order left to local officials the decision of whether to cancel schools and or religious services. The restrictions were lifted on November the 9th, 1918. So the restrictions were in place for about a month and 10 days, because the restriction was put in place October the 4th, 1918, and it was lifted November the 9th, 1918. It lasted for a month. Wow. A comprehensive study of non-pharmaceutical interventions used in various cities in 1918, excuse me. A comparative study of the non-pharmaceutical inventions used by cities in 1918-1919 shows that state and local mitigation measures were of similarly short duration across the nation. While unquestionably state and local governments restricted certain activities for a limited time to mitigate the Spanish flu, there's no record of any imposition of a population lockdown in response to that disease or any other in our history. So even where they were closing theaters and movie theaters and vaudeville shows and all the rest of it, they didn't attempt to lock down the entire population. Not only are lockdowns, not like the one imposed here, unknown in any response prior, they are not even mentioned in recent guidance offered by the CDC. So they're completely unknown in our history, and they weren't even mentioned in the most recent guidance that was published by the CDC, which incidentally was published in 2017. Made no mention of it. There are no recommendations in that document that even approximate the imposition of a statewide or even community-wide stay-at-home order or the closure of all non-life-sustaining businesses. Indeed, even for very high-severity pandemic, defined as one comparable to the Spanish flu. The guidelines provide only that the CDC recommends voluntary home isolation of ill persons. And CDC might recommend voluntary home quarantine of exposed household members in an area where a novel influenza circulates. This is a far cry from the statewide lockdown order. So even the CDC, in their latest guidance, which is 2017, said, in the event of Spanish flu, maybe you can isolate people that are exposed, and maybe you can isolate people in their family. They didn't dream of maybe you can isolate the entire state. This is unknown. This is unknown in our history, unknown to the CDC. Didn't even dream of it. The fact is that lockdowns imposed in the early 2020 in response to this pandemic are unprecedented in our history and in their country. They've never been used in response to any disease ever in our history period. They were not even in the recommendations made by the CDC. They were unheard of by the people of this nation until this year. We've invented whole new ways to oppress people. It appears as though the imposition of lockdowns in Wuhan and other areas of China, Wuhan, apologize, I know how to pronounce this name. Wuhan. No, that's wrong. China, I've forgotten how to pronounce this name in China. I've forgotten. Wow. I'm sorry. I used to remember and I've forgotten. Wuhan. Thank you. Wuhan. Jeez, I've forgotten. Wuhan. Thank you. I couldn't get there. It appears as though the imposition of lockdown in Wuhan and other areas of China, a nation unconstrained by concern for civil liberties and constitutional norms, started a domino effect where one country and state after another imposed draconian and hereto untried measures on other citizens. Lockdowns are therefore truly unprecedented from this legal perspective. Yeah, so we never dreamed of this before. The stay-at-home orders strictly limit the right of movement, confining citizens to their homes unless they have specific permission to leave enumerated in the order. That is, the stay-at-home orders impacted liberties not only merely limited to the act of traveling, but the very liberty interests arising from the fruit of travel, such as the right of association and even the right to privacy. That is, the right to be left alone while otherwise acting in a lawful manner. Our courts have long recognized that beyond the right of travel, there's a fundamental right to simply be out and about in public. People have the right to be out and about and stuff. Yeah. I like this comment from Richard very much. Some people are sick. Guess we better declare martial law and lock you up. It's not quite martial law, but your point is well taken. Yeah, that's kind of what's been happening. The orders are such an inversion of the usual American experience that this court believes that no less than the highest scrutiny should be used. Strict scrutiny. However, the court also believes that they'd fail under even intermediate scrutiny. Because they're so all-expansive, we're going to say strict scrutiny, but they'd even fail intermediate scrutiny. A critical element of intermediate scrutiny is the law challenge being narrowly tailored, so it doesn't burden more conduct than's necessary. The stay-at-home orders far exceed any reasonable claim that would be narrowly tailored for intermediate scrutiny. Defendant's order, which incidentally, if it's not intermediate scrutiny, it's not strict scrutiny, so, there's that. Defendant's order subjected every Pennsylvanian to a lockdown where he or she involuntarily committed to stay at home unless he or she was going about activity approved as an exception to the orders. Even most recently and currently applicable, iteration of defendant's orders while the operation of the stay-at-home provision is suspended is not rescinded and may be reimposed at any time at the sole discretion of defendants. Thus, the orders have created a situation where the default position is lockdown unless it is suspended at their will. When in place, the stay-at-home order requires a default of confinement at home unless the citizen is out for a purpose approved by the orders. Moreover, the situation applies indefinitely. $10 from War Hero 89. Drink for the host. Good content. Thank you very much, War Host 89. Your donation is extremely appreciated. This broad restructuring of default concept of liberty movement in free society eschews any claim to narrow tailoring. Yeah. In addition, the lack of narrow tailoring is highlighted by the fact that broad, open-ended population lockdowns have never, in italics, been used to combat any disease. In other words, in response to every prior epidemic and pandemic, including the more serious ones, such as Spanish flu, state and local governments have been able to employ other tools that did not involve locking down their citizens. I like this. I like this a lot. This is really, really good. This is really, really good stuff. I like this, the way this is written. This is very well written. This is very well thought out. The court declares, therefore, that the stay-at-home component of the order were and are unconstitutional. Broad population-wide lockdowns are such a dramatic inversion of the concept of liberty in a free society as to be nearly presumptively unconstitutional unless the government can truly demonstrate that they burn no more liberty than is necessary to achieve an important governmental end. The draconian nature of the lockdown may render this a high bar indeed. Nice. Next up, the defendants argue that the business closure violates due process. So now we're going to talk about the liberty interests of the business owners. We talked about the liberty interests of Pennsylvanians. Let's talk about the liberty interests of the business owners. Great. So let's discuss them for a little bit. The order states in relevant part, no person or entity shall operate a place of business in the Commonwealth that is not a life-sustaining business, regardless of whether the business is open to the member of the public. The order attached a list of life-sustaining businesses that are permitted to stay open. Defendants also set up a waiver system whereby a defendant could be deemed to be non-life-sustaining, could request permission to continue operation. $20 from Wes S. I'd appreciate if you reviewed Brendan Dassey versus Michael Dittman, 7th Cert en banc. Okay, I will make a note of it before I forget, so that I will make sure to cover that. I will cover that on a subsequent stream, so let me make a notice of that before I forget. Hold on. All right. It's on the list. Thank you very much. Now we're away. As with the lockdown, the defendant's shutdown of all non-life sustaining businesses is unprecedented in the history of Pennsylvania and indeed the nation. While historical records show that certain economic activities were curtailed in response to Spanish flu, there's never been an incident where the government or an agent has, on their own initiative, divided every business in the Commonwealth into two camps, life-sustaining and non-life sustaining, and closed all businesses deemed to be non-life sustaining unless that business obtained a waiver. The unprecedented nature of the business closure, even in light of historic emergency situations, makes examination difficult from a constitutional perspective. It does not fit with any precedent ever addressed by the court. You've come up with whole new ways to oppress people, so we don't know exactly what to do, but we're going to figure it out because we're a good court, and we'll figure it out. No one else has done it, so yay, it's up. It's up to us. Never before has the government exercised such vast and immediate power over every business owner, and employee in the Commonwealth. Never before has the government taken direct action which shuttered so many businesses and sidelined so many employees and rendered their ability to operate and work solely upon the government's mercy and wills. The business plaintiffs argue the business shutdown orders violate the right to substantive due process under the 14th Amendment. Specifically, they contend the designation of some businesses, including all businesses as not life-sustaining, and closing them violate their right to engage in commonplace occupations of life and to engage in the pursuit of chosen profession free from unreasonable governmental interference. $20 from Adam W. Can you cover Wolf versus Canary? Involves Pennsylvania title whatever. Assembly by concurrent resolution may terminate a state of disaster emergency. The legislature passed the resolution and the Supreme Court of Pennsylvania denied it. Well, I mean, I'm not an expert on Pennsylvania law, but normally the term concurrent resolution suggests it's not legally operative. If you normally when you pass a I mean, this is the way it would be under U.S. law. So I'm imagining it's the same as in Pennsylvania law, and maybe the reason why. But I'll cover the case for you. But I'm going to give you what I think the answer is based on just what you told me. So based nothing more on the question, here's what I think the answer is. There's a difference between a joint resolution and a concurrent resolution. A joint resolution, at least in federal law, a joint resolution would be passed by both houses of Congress and signed by the president. That would be law. A concurrent resolution is just passed by both houses of Congress and is not signed by the president and therefore is not law. It is simply the opinion of both houses of Congress. So I'm going to guess that the reason that this came out this way is because it was passed by both houses of Congress but not signed. The name concurrent resolution suggests that it merely operates as the opinion without legal operative effect. So that is my guess of why that case came out that way, because of the exact wording of it. But I will get into it and we will look into it. Awesome. All right. The Due Process Clause of the 14th Amendment involves a substantive component that bars arbitrary, wrongful government action regardless of the fairness of the procedures used to implement them. Contrary to the argument, the right of citizens to support themselves by engaging in a chosen occupation is deeply rooted in our nation's legal and cultural history and long been recognized as a component of liberties protected by the 14th Amendment. Over a century ago, the Supreme Court recognized it requires no argument to show the right to work for a living in common occupations of the community is of the very essence of personal freedom and opportunity that was the purpose of the 14th Amendment to secure. So there is generally a right to work. The Third Circuit has recognized the right to hold specific private employment and to follow a chosen profession free from unreasonable government interference comes both within the nature of liberty and property concepts of the 5th and 14th Amendments. Before proceeding to the applicable constitutional scrutiny, the court will first address the fact that, as defendants have pointed out, the closure of non-life-sustaining businesses was only temporary. So the governor says, we only did it for a little bit, so we cool? The governor argues that this precludes a claim that the 14th Amendment was violated because it only happened for a little bit and therefore doesn't count. Although the closures were ultimately suspended, of course, the order itself has no end date. So, yeah. So this thing that doesn't really count, the people who are suing would like to tell you why it does count. It doesn't really count because it doesn't apply anymore. Here's why it does count according to the plaintiffs. The record shows the impact of the shutdown, even though temporary, was severe, you don't say. For example, McDonald & Sons, a small business, estimated that it lost $300,000 in revenue, and its business has been financially devastated. McDonald, not the burger guy, expressed ongoing concern that restrictions may be reimposed, which could be fatal. Some other people explained the loss to their salon exceeded $150,000, and they depleted the entirety of their emergency fund to pay the expenses that came due when their business was required to remain closed. Yeah. And thank you, as always, to Streamlab, my bot, for your reminder. For 99 cents, you can join the Uncivil Law Army. You should hit the join button and become an uncivilian today. Thank you, Streamlabs, for the periodic reminder. It is appreciated. The Supreme Court has recognized the core of the concept of substantive due process is a protection against arbitrary governmental action. Indeed, the touchstone of due process is the protection of individuals against arbitrary actions of government. Rational basis review is forgiving, but it's not toothless. So at the bare minimum, at the very bare minimum, the government has to act rationally. It's really not hard. Did Pennsylvania manage to screw even that up? Did they manage to do something that wasn't even rational? Government has to be at least at the minimum rational. Did they screw that up? Let's find out. As a general matter, the rational basis test requires only a rational relationship to some legitimate end. If this sounds like pretty broad language, it's because it is. Conversely, actions which are irrational, otherwise known as arbitrary and capricious, that's another way of saying irrational, do not bear a rational relationship. Yes, arbitrary and capricious is not rational. Deep thoughts. Yes, that's true. All right. The record shows that the governor's team, which designated the business and countless other businesses as non-life sustaining, and thereby closing them, did so with no set policy. Indeed, without even forming a definition of life sustaining and non-life sustaining. They had no policy, they had no definition. They were throwing darts at a board or cutting heads off chickens, one of the two. The term life-sustaining and not life-sustaining relative to businesses are not defined in any statute or regulation either. Mr. Robinson explained that the policy team used the North American Industry Classification System as a component. This manual is used by federal agencies for classifying businesses, but the manual itself does not define life-sustaining and non-life-sustaining. These are categories we made up. We had no policy. We had no practices. We were just assigning people into boxes based on our whim. And you might be thinking to yourself, that sounds like it might be arbitrary. That sounds like it might be capricious. There's no policy. They didn't even attempt to form a definition. They're just putting people into boxes. That sounds like it might be arbitrary. That sounds like it might be capricious even. The manner in which the defendants, through their team, designed, implemented, and administered the closures is shockingly arbitrary. Yep. The policy team was not tasked with formulating a theoretical policy paper or standard to categorize abstract businesses. Rather, it had the authority to craft a policy adopted wholesale by the government. that had immediate impact on the plants and countless other businesses across the Commonwealth. Despite the fact their decisions had the potential, and in many cases the effect, of destroying businesses and putting employees out of work, defendants and their advisors never formulated an objective definition. Never bothered to form a definition as to what constitutes life-sustaining. Never bothered even to try. The court recognizes defendants were acting in haste to address a public health situation. But to the extent defendants were exercising raw governmental authority in a way that could, and did, critically wound or destroy the livelihoods of so many, the people of Pennsylvania at least deserved a plan. A plan of some kind. The ability to determine with some kind of certainty how critical classifications were made, and a mechanism to challenge those classifications. Didn't even come close. An economy is not a machine that can be shut down and restarted at will. Deep. It is an organic system made up of free people, each pursuing their dreams. Oh my God, the judge is a capitalist. Oh my God, the judge is a capitalist. Whatever will we do? The ability to support oneself is essential to free people. The late Justice William O. Douglas observed, "The right to work, I had assumed, was the most precious liberty that man possesses. Man indeed has as much right to work as he has to live, to be free, or to own property." The American ideal was stated by Emerson in his essay on politics. A man has a right to be employed, to be trusted, to be loved, to be revered. It does men little good to stay alive and free and propertied if they cannot work. To work means to eat. It also means to live. For many, it would be better to work than to be in jail, than to sit idly on the curb. The great values of freedom are the opportunity afforded to man to press on to new horizons, to pit his strengths against the forces of nature, and to match skills with a fellow man. These words were written by a former Supreme Court justice. Pretty good stuff. In a free state, the ability to earn a living by pursuing one's calling and supporting oneself and one's family is not an economic good, it is a human good. So it's not just economy, it is in the nature of man itself. Deep. Although jurisprudence may not afford the right to pursue one's occupation with the same weight as other liberties, so it's not necessarily on the same tier as other liberties, but it cannot be given such a short shift as to allow it to be completely subordinate to an ad hoc, which is, chicken dancing with its head off, an arbitrary regime that cannot even be reduced to an objective, written definition, even when the regime is based on good intent. The record shows that they were doing so were so arbitrary as to violate the substantive process. So you know how rational basis is really, really low. You know how rational basis review is really, really low because it just has to be rationally related to any purpose. Fail. You failed rational basis review. Ouch. Ugh, that hurts. Finally, the court examines whether these closures violated equal protection. So did we treat some businesses differently than others for not very good reasons? The business plaintiffs have demonstrated they were treated differently than other businesses that are similarly situated. That would be like not equal protection. You can't do that, right? If some businesses are in the same situation as other businesses, you can't treat them differently. Well, how did we do that? I'm so glad you asked. Here's how we did that. McDonald & Sons is a retailer that sells furniture and appliances. So is Walmart, Lowe's, and Home Depot. The only difference is the extent of the offering, and presumably also quality. Walmart, Lowe's, and Home Depot are larger and offer more products than McDonald & Sons. However, in essence, they're the same. Retailers selling consumer goods, such as furniture and appliances. Likewise, the salon plaintiffs, in their role as retailers of health, rather than performing personal services, are similarly situated to big box retailers and drugstores that also sell these beauty products. Again, the only distinction is size. Nevertheless, the defendant's orders treat these retailers different than their large competitors, which were permitted to remain open and continue offering the same products that these people were forbidden from selling. So Walmart, Lowe's, and Home Depot were permitted to sell furniture and appliances, but not McDonald. Even though they're both furniture and appliance stores. The only difference is one's bigger than the other. But McDonald can't be open and Lowe's can. Why? The record unequivocally establishes the distinction was made intentionally. So the final question is whether there's a rational basis. Is there a reason? Any reason? Any reason at all to treat these businesses differently? That would be super helpful. The manner in which they chose these categories, however, fails rational basis scrutiny. The court outlined at length above the facts determining whether they would be deemed life-sustaining and non-life-sustaining was arbitrary, ad hoc, and a process they are never able to reduce to a definition. As stated above, to the extent the defendants were going to exercise an unprecedented degree of immediate power over business and livelihood, to the extent they were single-handedly going to pick which businesses could stay open and which must close, and the extent they were picking winners and losers, they had an obligation to do so based on objective definitions and measurable criteria, like, rationally. The Equal Protection Clause cannot countenance the exercise of such raw authority to make critical determinations where the government could not at least enshrine a definition somewhere. You had no definition that was putting McDonald and Son in one category and Walmart, Lowe's, and Home Depot in the other category. No definition at all. Just making it up. Finally, as if this wasn't enough, we're going to beat you over the head some more. Finally, the record shows that this distinction did not even go to your purpose. So that's how bad it is. That's how bad it is, kids. It is so bad. It is so bad that not only did you have no definition, it is so bad that not only did you treat similar businesses differently, it is so bad that even as you were doing all those things, you couldn't even meet your own goals. That's how bad it is. Not only were you doing it ad hoc without any definition, not only were you doing it in ways that were treating two businesses, which are the same, differently, but you couldn't even do it in a way that met your own goals. So even in your arbitrary, capricious nature, you couldn't meet your own objectives. Wow. That's a whole new level of incompetence, guys. Not only were you Caesar, you couldn't. Not only were you Caesar as you seized control of the entire domain of enterprise. Not only were you Caesar, but your dictates didn't even work. Nice. The purpose of closing the non-life-sustaining businesses was to limit personal interactions. Miss Bodinger, again, averred, which is to say offered, in an effort to minimize the spread of COVID-19 throughout Pennsylvania, the Department of Health sought to limit the scale and scope of personal interaction as much as possible in order to reduce the number of infections. Accordingly, it was determined the most effective way to limit these interactions was to allow only businesses that provide life-sustaining services or products to remain open and issue stay-at-home orders directing people to leave their homes only when necessary. But defendants' actions did not rationally relate to the end. Closing McDonald and Son, the furniture store, did not keep at home a consumer looking to buy a chair or lamp. It just sent him to Walmart. Yeah, refusing to allow the salon plaintiffs to sell shampoo or hairbrushes did not eliminate the demand for those products. It just sent them to Walgreens. So you completely failed in your own goals. The consumers are still consuming. They're just consuming at big box stores. So it's not that they weren't able to go out and spread the disease. They just were doing it in other places because you failed. That's a special level of F. That's a special level of F. We need new grade letters to define how big a fail that is. In fact, while attempting to limit interactions, the arbitrary method used by defendants almost universally favored businesses which offered more rather than fewer products. As such, the largest retailers remained open and attracted large crowds, while smaller retailers were required to close. That's how bad you failed. You sent everyone into the same place at the same time. Way to go. The distinctions were arbitrary and capricious. They do not rationally relate to their own goal. They violate equal protection. Man, this court is just beating Pennsylvania to death. Beating them to death. And I love this language. I love the way this guy writes. He's a good judge. I like the way this writes, and this could become a model for language. So finally, we get to the conclusion of our grand tale. And now we're in 23 in, which isn't too bad. I thought it was going to take longer than that. We actually did pretty well today. So how do we want to wrap all this up? How do we want to tie a bow onto this parfait, which isn't really the right expression, but whatever. It's my channel. The court concludes this opinion as it began. By recognizing defendant's action at issue, we're undertaken with good intentions. So I'm going to pat you on the head before I beat you to death. But even in an emergency, the authority of government is not unfettered. The liberties protected by the Constitution are not fair weather freedoms. in place when times are good, but able to be cast aside in times of trouble. There's no question this country has faced and will face emergencies of every sort. But the solution to the national crisis can never be permitted to supersede the commitment to individual liberty that stands at the foundation of the American experiment. The Constitution can never accept the concept of a new normal, where basic liberties of people can be subordinated to open-minded emergency mitigation measures. Oh, burn. So much burn. Oh, what kind of salve do you need for that burn? Ooh. Rather, the Constitution sets certain lines that may not be crossed even in an emergency. Actions taken by defendant cross these lines. It is the duty of the court to declare those actions unconstitutional. Thus, consistent with the reasons above, the court will enter judgment in favor of the plaintiff. Sincerely yours, this love letter has been signed by William S. Stickman IV, United States District Judge, who has a very funny looking signature, but is a great writing style. And he actually writes fourth in his signature, which is kind of funny. But, all right, that's cool. That's, his style. He actually puts fourth in his signature. That's kind of funny. He really wants you to know he's the fourth, man. Oh, thank you, Watching You Daily. Yeah, thank you for Watching You Daily. Thank you to everyone else who suggested this story. I really appreciate it, and I really value it. So I appreciate it. So we'll wrap it up. So we did pretty well. For 66 pages, we did an hour and 25 minutes. Obviously, we skipped a lot of history. We skipped some other stuff, but, I thought we covered the stuff I thought was important. So, there you go. We covered the stuff I thought was important, and I thought did a very good job of covering the story. So, of course, the government can appeal. They can appeal, and who knows what the Court of Appeals might do. But we'll see what happens. Good thing the fourth is with us. Depends which time. 355 people are watching me right now. Excellent. That is a very healthy turnout. Thank you, 355 people, for tuning in. I really sincerely mean that. Thank you. That's getting close to record. I mean, when we had the 4-hour live stream, for some reason we had 500 people, or maybe 600 people. But for like a normal stream, 355 is like pretty close to peak record. So thank you, everyone, and I hope that you enjoyed this reading and explanation. And I hope that I paused sufficiently often to explain things without being patronizing, and I hope it was informative and was educational and all that good stuff. I hope you really, really enjoyed it. So the governor may appeal this to the court. Is Pennsylvania in the Third Circuit? I think Pennsylvania is in the Third Circuit. Hold on. Where's my circuit map? Is Pennsylvania in the Third Circuit? Yes, it is. That's what I thought. So they can appeal this to the Third Circuit, and we'll go from there. Third Circuit Court of Appeals, and we'll see what happens. So, I don't know. But as I pointed out, there's a couple things that are here. There's a couple things that are noted. First of all, this is very well written. The only really major point of distinction, I think, well, the most obvious point of distinction, let me put it that way, is the first one, the Jacobson case. So if you think Jacobson is controlling, then this analysis probably goes the other way. So Jacobson, with the vaccination case from 1905, the degree to which you think that is controlling or not probably dictates a lot of this. So if you think as a legal scholar Jacobson is controlling, then this case probably goes the other way. So that would be the most obvious way to reverse this, it seems to me, is to say that the district court got it wrong and Jacobson was the case that should be applied. And so to go analyze it under the more strict standard. And then you're going to have a bad day. You're probably going to have a bad day if you're under Jacobson. The thing that sort of counsels against that is, as I pointed out, Jacobson was decided before we came up with the three-part test we normally use, and no one super loves it. So I don't know that a court necessarily is thrilled to invoke it, but they could. They could invoke Jacobson. So that's the most obvious way to overturn this if you were the Court of Appeals, is to invoke Jacobson and say, no, because this is a public health emergency, Jacobson applies and you should go reanalyze it under that. So that would be the most obvious thing. Apparently Stickman is a Trump appointee. Well, apparently Trump can appoint some really good judges, because this one can write really well. Watching You Daily says, I don't think Jacobson applies here because the fact pattern is too far off. Fair enough. There was that other case from 1910, which we covered on my channel too, which dealt with more with quarantine orders, which has some similar language in it too. And there was that other case from around that time period, like 1908. So it was Jacobson in 1905. There was a quarantine case in 1910 from Louisiana, which had some similar kind of language in it, and one from 1908 that had some similar language. We covered it before on my channel. So there is some cases there that could be read that way, but I think that this analysis makes more sense. You know, if I were a judge, I would not want to invoke Jacobson if I didn't have to, not for least the reasons that it's just so far in a field to what we're used to doing. Wolf versus Scarnetti. What's Wolf versus Scarnetti? Wasn't that one someone recommended? Oh yeah, someone recommended it earlier. Yeah, Wolf versus Scarnetti is on my list for a future stream. We'll probably do it. We'll probably do it this upcoming Sunday or something. But yeah, we'll get around to it. It's on the list. Yeah, it's on my list. And yeah, and we'll have to see if the reason for Wolf versus Scarnetti is because of the concurrent resolution. If it's pronounced Scarnati. Okay, Scarnati. Fair enough. Scarnati. Fair enough. So we'll get to it in a future stream and see if that goes that different way. So yeah, we'll absolutely do that. But yeah, going to like those quarantine cases, Jacobson, going to those cases would be the most obvious route to go. But I wouldn't do that if I were a judge because one, it goes against the constitutional analysis we now use. Two, it's kind of before the Supreme Court recognized the Bill of Rights as a thing that maybe we should pay attention to and maybe occasionally apply, which started around the 1930s, depending on your framework. And yeah, so I wouldn't apply it unless I had to. So yeah, but we'll see what the Third Circuit wants to do. But I hope you enjoyed the stream. If you have not already done so, if you'd be so kind as to give it a like on your way out, I would appreciate it. I would appreciate it very much if you would give me a like on the way out. I spend this time for you to try and inform you, and I hope you found it educational and informative. I try really, really hard. What's the odds of getting a video of Buck v. Bell? It's on my list of things to do. It's on my list. So occasionally we will definitely get around to it, and we'll do one on Buck v. Bell. It's on the list. Yeah. And if you haven't already, if you'd be so kind as to join, somewhere on your screen, somewhere where the subscribe button is or should be, there should be a join button. For 99 cents a month, you too can become an uncivilian and help show my support. And incidentally, the channel just cracked 12,000 subscribers, so that's pretty cool. And we will probably announce a subscribe star. I'm not going to use Patreon, but we'll announce a subscribe star in the near future. I have the page up and running, and we'll probably announce it and start running with it relatively soon. I haven't decided, but maybe occasionally, so we'll see. So until later, my friends, I hope you enjoyed this. Until later, have a good one. Cheers and goodbye.